in second year.
Okay. Oh, so you already know the basics of IP, I guess.
Yeah.
Okay. So I'm just covering some slides which I think would be new to you guys or relatively new, or it could be a refresher as well. So IP more or less is defined as ownership of ideas, control over tangible, virtual representation of those ideas. Ideas, it could be thoughts, it could be something creative, um, or it could also be a product of intellect that has a real commercial value. It has a value in the real world, but we'll talk more about it in the further slides. So what is IP? Intellectual property. It encompasses ideas, expression of ideas, the manufacturing processes. It is also encompasses consumer goodwill, how we do business, and many more things. But out of all those long list or branches of IPR, the most common types or categories are is a copyright. It's the other one is trademark, and the other one is patent. So in this session, we are more or less going to talk about patent. Um, but trademark, as you all know, or some of you might have come across this, a company name, a firm name, or an organization, um, or a product itself has a trademark mentioned on it, on its name. It could also be a phrase, it could be a design that is trademarked, it could be a logo. Most of the times, it's the logo that is trademarked, which protects your goodwill that the logo or the company has built on that trademark, to protect it from being easily copied or easily used by others, because goodwill takes time to build, and somebody else cannot just use the same goodwill that somebody has else has taken over time, and it's a lot of sweat and blood that goes into it. So it's just to protect the goodwill of um, of a product, of a logo, or basically the building of a brand. And then there are copyrights, wherein um, could be songs, it could be short videos, short films, etc. That could be copyrighted, where you have to get the rights if you want to use. So if you go to YouTube and try to play a song, more or less you'll see, if somebody else is using somebody else's songs, it is copyrighted. They need to get permission from the real author, um, or the real producer to get to use it, anywhere else. So let's talk more about patents. So before we jump onto patents, why is IPR vitally so important to a business? It's so critical. Companies go to law offices, hire lawyers, expensive lawyers, fight day in, day out to protect their IPs. But why is it so critical? Why is it so important? So IP is something, it's a primary source of profit. You could sell hundreds of products, thousands of products. You can follow tens of processes. But if you have or if you hold the rights to that particular product or process, you basically have monopoly over that. Now, depending on what your TAM is or target accessible market is, that you can, if you have an IP, you can capture the entirety of that particular product if you own an IP or if you have the rights to that product. It often defines a business. So, let's talk about masks here. Last 2 to 3 years, we got used to these masks. It was came into limelight. uh, 3M, a very well-known company producing N95 masks, it has over 300 patents just over, you know, three-layered masks. That is basically SMS fabrics and non-wovens, but don't want to go in detail over there. But due to which, it was a very major shareholder of the masks, face mask market in the world. I was just going over through one of the news articles, probably a year back, and 3M as a company has earned around $40 million just by fighting over different businesses or different business owners on trying to sell 3M's product under their own name. Since 3M was the original IP holder, or 3M had the rights to use that product, nobody else in the market can um, sell without the rights to sell it, um, the same product or a similar product without defining its own IP. IP also directs the growth of a business, as we discussed, and it often dictates the success of a business. It can draw in investors, it can draw investment capital. Investors, if they are really interested in the IP that you hold, they have a proper path to commercialize the product or capitalize the market. They can invest not in the IP holder, but in the IP itself. Um, there are people after having different patents or IP rights, they can also sell an IP or transfer an IP to an investor, venture capitalist, etc., so that they can drive more business using that IP, and you can either get royalty from it. So let's say if you hold an IP for a mobile phone, um, and every mobile piece sold with that IP or inside under those IP, you get a share or a stake of that selling price as a royalty to you. So you don't have to do anything. Once you have an IP, you go to Apple, you give them this IP, and every mobile phone that they sell, you get a royalty. You get a piece of share from that phone or from the earnings of that phone. So that's just money sitting at your home. So we already discussed about trademarks, copyrights. So usually, I would say typically it seems probable that majority of the inventions actually patented turn out to have little or no commercial value. So there are more than hundreds of thousands of patents filed worldwide, um, or hundreds of thousands of patents granted worldwide, out of which only a very, very, very few portion of it has a real value. Um, but just as the saying, not every horse gets placed in a race, but those which do make the race very attractive. So that is where the incentive is. So therein lies the incentive. So out of just talking about 3M again, it has more than it has thousands of patents within the company, but they only use a very, very, very few portion of it. Um, so talking about the rights of a patentee, whoever is filing a patent or owning a patent is called as a patentee. A patentee, he or she has the legal right to exclude others, basically anybody else in the market, from making or using or even selling the same product or a process for sale or importing the patented invention. Also, a patent does not give the patentee to the right to make, use, or sell the patented invention. So what I mean by this, the second point is, let's say I come up with a new flavor of an ice cream and I apply for a patent. I get a patent on the procedure of making this, not the procedure, but the ingredients in this ice cream. That does not give me the right to sell this ice cream in the market. And the reason is you have different organizations in different countries. So in US, you have FDA. You have to get approval from FDA. You have to go to file. You have to go to FDA, file an application, say that this is my patented ice cream, recipe. Um, and then it is up to FDA to allow you to sell it in the market or not. So having a patent does not necessarily mean you can sell the patent or sell the product. Sorry.
So,
Harsh.
Kiran here. What is FDA? What's full form of it? Or what it does?
I guess administration of drug or something. Let me quickly. Yes, US Food and Drug Administration. CC
Okay,
the
sir.
seal. I guess India has I forgot what India has.
Maybe sir FSSAI.
That's what I was thinking. But that's, I guess, a different association. Food Safety and Standards Authority of India. That's correct.
Sir, I think it's ITC.
No, I guess IDC is something else, if I'm not wrong. And ISI mark is also different. But anyway, let's get back to patents. All right. So any questions so far?
No, sir.
All right. Um, did you know this before on how long does a patentee hold this right? So once you invent something, once you have a patent to something, or once you have the rights on a product, you cannot hold it for your lifetime. You cannot hold it for lifetime. Um, you know, it's a common myth that once you have the right to a product, uh, even after you're no more in the world, you still have the right. So it is impossible or next to impossible for someone else to make it. So it's completely false. Um, you only own, and this is according to US Patent Office. I don't know if some of the things, more or less, there won't be a major significant change in India's patent policies. But in US, you own the patent for 20 years if you have filed it after 1995. But in today's age, you can adjust. You have a sliding option. It's basically a slider. It's up to you to decide um, um, on how long do you want to own this patent based on or contingent on approval. So you can apply or you can ask the patent officer to hold the rights to this patent for XYZ years, and depending on the officer, he can grant you that many years for holding the right. But by default, it's 20 years. So what does this tell us? Guys, why do we have a limit on holding a right to this patent? Anybody?
Hello, sir. Harish here.
Yeah, Harsh.
Yeah, sir. So basically, yes, sir, I think like if there is a limit, like the year is like 20 years, you can be patented, and then it is open to the public. So it invites innovations over to the company. So it help, like it encourages the company itself to innovate more, so they can pattern another innovation. Or if it's released to the public, then they can like look something more innovative in that pattern. So that's why.
So I'll just frame it differently, but I got your point. Harsh, really good point. So we don't want technology. We don't want to cap the technology. We don't want to restrict the growth on how the human race is progressing. But we also obviously want to have some competitive edge in the market, especially when there are so many multinational companies, big corporations running this, you know, the growth of human race. We just don't want to restrict the growth of technology. So any patent by default is just for 20 years. Once it crosses that, so a patent holder or a patentee can enjoy the benefits of holding a patent if it is successful for 20 years. Um, and then it becomes public. But here's what happens in the real world. Um, Companies or big multinational companies, they always find a way around when it comes to these patents. So, I was, my professor was telling me this case earlier. It is with three of the biggest companies, FMCG companies, Casey, Kimberly-Clark, P&G, um, and J&J, Johnson and Johnson. P&G is Procter and Gamble. So these companies, when they file a patent, they have a patent to or for a product or a process. What they usually do is they file a patent 5 to 6 years, or 6 to 7 years down the line of the same patent. They file another patent, which is more or less the same thing. They just find a way around to the original patent. So that is how they keep or they try to protect their own market and restrict others to enter their market. That's why it takes, you know, years and years and years for somebody else, excuse me, that's why it takes years and years for somebody else to stand up against them, um, trying to, compete with them in the same area, in the same industry. And usually design patents, they last 14 years. So, Apple, or let's say Android, um, Google, they have so many multiple different patents, um, but it just lasts for 14 years. Anybody can copy basically the designs, the design ideas or the design patent after 14 years. But just like the company Tesla, you know, um, very much in the news nowadays since he joined the Twitter board. He didn't join the Twitter board, he just owns a stake of it. But Tesla has all the patents public. They did not want to protect the patents to themselves, which was a very big deal in the early stages of Tesla. So each and every, or most of the Tesla patents you see are completely available to the public. So even though they were the early inventors of a particular product or a process, um, they did not want to restrict the growth. So they made all the patents available to the market. So it is still open, um, just one of the cases. But what is not patentable? You have laws of nature, you have Newton's law of gravity, you have physical phenomena that cannot be patented. You walk in a hilly region, you find a mineral that you think, wow, I just discovered something. So discoveries are not patentable. It should be, and it is completely available to the market. Yes, if you are an early owner of that discovery, you can have a name of a founder, but you cannot hold the rights to use that particular um, mineral or matter. Um, let's say you find a new plant or a new species of animal or something. You cannot patent them. Those are not patentable. So what exactly are the requirements of patentability? You know, Pranil, you're saying I cannot patent this. There are so many companies that already have patents with them. So is there something that I can really patent? And what is the criteria that that my product or my creative idea should have in order so that I can file for a patent? So it should have three basic requirements. It should be useful. It should be novel. It should be non-obvious. You cannot patent something which is so obvious, just like gravity. It is very obvious. You know, you cannot patent something related to a gravity. um, the apple's falling. It is so obvious it falls because of the gravity. So something which is not so obvious, or not so already patented, something which is novel, something which is not invented earlier, it is not used earlier. If you have an application, for example, a novel application of a material, it could be patented. Um, it should be useful to the public. It should be something that has its use. Now, usefulness of a product is very subjective. And we'll talk more about the usefulness in the later slides. But what is useful to me cannot be useful to you, can be useful to somebody else. So it is a very subjective matter here. But something in general which is useful, um, there could be a very, 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 very niche category of people, or group of people, category of people that this product can be useful for. It does not depend if it's useful for animals, for trees, for living or non-living objects, but it has to be useful in some or the other way. So what are the steps for obtaining? But before we jump onto the steps, do we have any questions or comments so far?
So
Hello, sir.
Yes, who's this?
Sir, Vaibhav, sir. Sir, can you
Yes.
further elaborate requirements of patentability?
All
Did
right.
not, sir, understand.
So there are three requirements, Vaibhav. Basically, let's say you are going to file a patent. It has to be useful. So when I say useful, something which is useful to me is not useful to you, but it is useful to somebody else, right? Um, so this is very subjective. You go back and forth with the patent filing officer or patent officer on the usefulness. You select or you decide a particular market that you can target, or what is the target market. It has to be useful and it has to have its own results in order to be patentable. So let's say you are claiming this product that is useful for elders. Um, so what are the benefits? So when you are claiming that this product, increases or reduces the wrinkle of elder people, so it should be useful in some or the other way. It should have its own results. You should have supporting documents to support the claim. So the second requirement is novel. It should be novel. It shouldn't be a replica or something repetitive from previous patents or something that is already in the market. It should be something unique. Um, the third point here is it should be non-obvious. You cannot patent something which is very obvious to the world. So let's say you come up with a calculation, you cannot patent a number. You cannot have a number of your own. You cannot patent an addition or subtraction of a number, which is very, very obvious. Um, you cannot patent bouncing of a ball because it bounces. It's just obvious. It's how it reacts. And coming back to this, more or less the non-obvious portion relates to this. You have gravity, you have different formulas, you have minerals, you have plants, trees, you have animals, species that you cannot patent. So something which is non-obvious is something that you can patent.
Yes,
Is
sir.
that clear, Weber?
Yes, sir. Clear. Thank you.
Because there was somebody else.
Yes, sir. Hello, sir. Harish. So, I watched there was a video and they were talking about like these scientific discoveries kind of, but not exactly discoveries, but they were like just theories and all, and they were like, okay, we can patent that, we can patent that. But sir, like if the particular theory is actually in the nature, then it is not patentable, right?
Right.
So if it's not in the nature, then it's, for example, super semiconductors like to 0 Kelvin. Oh yeah, minus 73 Kelvin, something like that.
Mm-hmm.
So that's in the nature. But if I discover that I can't patent that, right? Or I can.
So the material in itself, which comes from nature, you cannot patent that. But the process on how you extract that material, how you use that material could be patentable.
Okay, so like full process of making that particular material super semiconductor is patentable, not
Right.
material.
And even the product itself, like when you make a semiconductor out of that raw material,
Yeah.
it is patentable.
Okay, so it's like final end product is patentable.
The end product, the process, but the raw material itself is not patentable. So let me be more specific here. You come up with a recipe on growing a cotton, right? You use some chemicals, you use some organic matter, and you grow cotton, which increases the yield by, let's say, 20%. uh, that recipe itself is something that is patentable. So you can patent or you can file for a patent claiming that if I use this, this, and this, I mix it up, I grind it, I apply, I sprinkle it on the ground, in the soil, blah, 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 blah. So that process itself is patentable.
Okay. Yes, sir.
Friends?
Yes, sir. Thank you, sir.
Right. All right, so we discussed what a patent is, what are the requirements of a patent, what are how do we make business, or why is it so important to a business? But going back, how do we actually obtain a patent? How do we maintain it once you obtain a patent? So there is a process flow, and this similarly acts to the phase gate process that we discussed in the first session. I hope everybody remembers that. Um, you do something, if it fulfills the criteria, you open up the gate, you go to the next phase, you ask questions, you do some research. If the answers you find fulfills the questions or the needs or fulfills the criteria, you open up the gate, you go to the next phase. So starting from, let's say you're walking down a street, you think of something, you think of a product. Hey, this is a new product I can think of. So what would you do if you want to file that thought as a patent or that product as a patent? So you go home, the first thing you would do, and I'm just talking about basic steps, okay? This could be very, very subjective. So you go home, you open up your laptop, you fire up the internet, you search for anything that relates to that product. You do your research on previous art or prior art or background study of an existing art. There are patent websites, patent offices, where you can find all the previous artwork that has been filed of that particular product. You know, you do the research, you read existing patents, um, and then you decide if what idea you have or what thought or what product you have is something unique, different than what is already available in the market. Um, and if that answers all your questions, you go to the next step, which is opinion of patentability. So patents, what is your opinion on the patent? Is it useful? Is it non-obvious? Is it novel? Is it unique? Is this something already previously done before? If it's not, how do I find my way around this patent, etc.? The next thing, if it is patentable, you come across, you answer all the questions, you find this is really something new. It has its own market. You want to get it filed, uh, specific to India, based on the majority of the crowd here. We go to the website, you file an application. I was actually looking to the website earlier. IPR. So this is the website you would go to. Everything has been so modernized and digitalized now. Earlier, I don't know how long back, but I heard from my professors they used to actually, um, write down forms, fill up forms for application of patents. They used to post it, mail it to the office. You don't even know if it's going to reach there, if it's not, blah, blah, blah. But now everything is online. You can go to this website, you can file a patent right over here. And I'll show you in a while how the application looks like and how do you file or write a patent itself. The next thing you would do is publication of the application. So 18 months, and this is a general rule by default for patents worldwide. 18 months into the application, the patent becomes public, or the application of that particular patent becomes public. But now it's also up to you. If you have everything ready, if you have everything prepared, and if you're ready to file for examination, you can go ahead and request for one. But 18 months is how long it takes to make the application public. Um, Professor Katkar, I would just ask for your expertise here. If I'm stating something or claiming something next to incorrect, so
No,
feel
no.
free to correct me because you've already filed a patent. But just so everybody knows, I'm not a patent expert. I just know and find my ways around different things. I'm just a curious mind. So I don't have a patent of my own. I I have never filed a patent before, but I just know how this process flow works. Um, so yeah. The next thing, once it becomes public, is you request for examination. So you file or you submit your paperwork. If there are any corrections or modifications, you have that 18-month period. You can go back, modify your paperwork, correct some things if you find something new or something different to add in the paperwork or in the application itself. You have that time frame. But once it's ready and once it's public, you can request for examination. But before you request for examination, I just bring this point. The reason you make it public, um, or a patent public, is because you want to, um, you know, have your name public for the for the patent. And what I mean by this is patents are first come first serve basis. So if Vaibhav is thinking of a patent, he's just thinking, he's just working, but Harsh goes and files the application for that patent before Vaibhav does. By default, the patent goes to Harsh if it is accepted. Even though it's Vaibhav's idea, Vaibhav came up with this. He has a brilliant idea and a product, but he has to file that patent before Harsh. But if Harsh files that before Vaibhav does, no matter what was the contribution from Harsh, it by default goes to Harsh. So Harsh would be the patent owner of that. And that is why you apply for a patent and then it becomes public. Another reason to make it public is also if somebody already has an existing idea or already is working on it, he or she can go and look for that application and see what is the claim made for that particular application. Then it goes for request for examination. This is the step where you are assigned an officer or a group of committee in some cases, where they briefly, or they not briefly, but they go through your application in detail, word by word, sentence by sentence, paragraph by paragraph, um, in detail, and examine the applicability of this patent. Then most of the cases, from what I've heard, there are objections raised, there are flags raised in the application where they have questions or objections as to the claims you're making. It could be, why is this unique? It could be as simple as, why do I grant this patent? What is unique in this? Or they have their own references, or they can cross refer it to another patent, and ask you to distinguish between the similarities. Um, then you respond to those objections where you say, in this patent, it is different than what I am claiming. This has blah, 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 but mine is something different. The approach is different. The recipe is different. The time, blah, etc., is different. So you respond to those objections to the best of your ability, to the best of the differences you can come up with. And depending, so these steps over here, respond to the objections and examination. It's a back and forth with the officer or with the committee. They ask you something. It's just like Viva. They ask you something, you answer those questions. They may have some additional questions or they may not. So at this point, it's up to the committee. If they don't have any questions, they can reject your application, and they will give you the reasons for rejection. So this matches with another patent. There is no distinguishing point. There is no difference here. Or if they accept the application, you have the grant of the patent. So you have been assigned a patent number, and you are now officially the patent of this. So this closes the entire loop of filing for a patent. The only last step remaining, and this is a recurring step, which is maintaining a patent. Patents, another myth with patents is once if you file a patent, it is not just you being the owner of the patent for 18 years, 20 years, 14 years, depending on what kind of patent you're filing. You have to pay recurring fees or you have to maintain that particular patent for those many years. Now, the reason I say this is because let's say, I guess we have a Kiran in the class, right?
Yes, sir.
So let's say Kiran is filing for a patent in India, and he wants to hold the rights to this particular patent in all the countries. So this would be a global patent. He has to also file or refer Indian patent number and make a similar claim in US Patent Office and similar global patent offices. But if he just wishes to secure this patent in India, he can also do that. But there are some differences, and I don't want to go into detail of this. Um, but he just wants to maintain this patent in India. What he has to do is um, pay the fees. And why he has to pay the fees is because even the patent officers, they have to process, they have to hire committees, they have to hire officers, they have to go through this procedure, they have their fixed maintenance costs, could be related to administration, building, expenses, different things that come along to maintain a patent. They have to document the records, they have to preserve all the filings, the patents, and everything. Um, once the patent is granted. So that is why you also pay maintenance fees. It's just like living in a building, there's a secretary, you pay maintenance every month, every 3 months, 6 months, depending, um, so that the building can be maintained. Now, Professor Katkar, just correct me if I'm wrong. There are some changes made to the maintenance part, um, especially in India. Um, the costs have been reduced to a higher extent. Maybe there are some categories where you don't have to, maintain patent. But I'm not really sure, and I'm not really up to date on the current scenario. All right. Any questions on this process?
Sir, Sakshi here.
Sir, yes, sir. There is a one question. Sir, can we apply the patent after the process or commercial or in ideation or early stage?
That's a good question. Um, I have little knowledge about this, but just based on my experience and my knowledge, I would say um, once you file an application, you can start processing unless there is a claim um, or someone files. Um, some other company files against you saying you cannot use this, wherein you have to go back and expedite this whole process. But to the best of my knowledge, I guess you can start commercializing once you file an application.
Yeah, Pranil, true. Actually, even we can patent once you patent the idea, then you'll get a period of, I guess, 1 year. That has to be confirmed. And then after completion of, like, he's asking about commercialization. Once he
Right.
patent his idea, he can go for commercialization
Right.
because his or her claim will be there in patent, patent office.
Right. But just to
Okay, ma'am.
Professor Patkar's point, they have to provide all the required paperwork, application, the whole um, patent
Yeah,
application.
claims and all. Everything is to be submitted.
Right.
It's a provisional patent.
Right.
Once you complete the whole process or the product, then you'll get a final patent. But then provision is there. You can have provisional patent. Of course, then time limit is there. It has to be completed within 1 year.
Right. So I hope that answers your question. Sakshi, you had another question, I guess.
Yes, sir. Like, sir, the patents are country specific, right? So, if I am patenting a product in India, and can USA based company can come with the same product and can they bring the product in our market, like in India?
So I guess I'm not really sure about this actually, and I would again refer to Professor Katkar, but from what I know, um, fighting for claims or fighting for patents is a very expensive process. So let's say I'm sitting here having a patent of my own. I have filed it in US office. I haven't filed it in India. Okay. So if you start using my
My
product
product.
and selling the same product in Indian market only, I can claim, use of my patent or use of my IP, but I have to hire a lawyer, pay those fees. I really have to see if it is really worth it or not, filing for,
Yes, yes,
fighting
that's
for
true.
this claim.
Yeah, that's true.
So, let's talk about iPhone here. You have Apple, based in US, manufacturing iPhones, selling worldwide. Obviously, they have different manufacturing sites, but they're headquartered in US, selling worldwide. But you have China, who is making duplicates and duplicates, first copy, second copy iPhones and selling worldwide. Now, it is really difficult to track unless there is a very, very, very big manufacturer in China, let's say Xiaomi, who comes up with a very similar design of an iPhone. And Xiaomi already has a huge market share in the world or in Asian market. And Apple, trying to sell their product in Asian market, can file or can fight for a claim in Asian market because Xiaomi is trying to copy the same product. So what will Apple do is Apple will fight with Xiaomi on grounds of copying the same product or using the same product, selling the same product. But Apple is not going to trace down each and every single, small makers or manufacturers or distributors, um, finding who is trying to copy their market. So it really comes down to um, who is duplicating this product in the market, who is commercializing it, who is or how big their market share is, and how it affects Apple or how it affects your company. And if you can bear those expenses, because then you will have to hire a lawyer in that specific region, fight those claims, go back and forth, etc., etc. But yeah, you can fight. Long story short, you can fight for the claim.
Okay, sir.
Hope that answers your question.
Yes, sir.
All right. So just a snapshot of what a basic application looks like. And just so you know, this is just the application. Um, there is a whole another paperwork that you have to submit along with this application, which entails your claims, your diagrams, if there are any, explanation of what is specific, what is unique of your patent. There is a whole detailed paperwork that goes along with this. But this is the initial paperwork that you would file to get your patent. So it consists of your name, basic ID information, what your nationality is, what is your residential address or corporate address, whatever. What is the title of the invention? Just the title itself. going to reduce my screen here. Okay. All right, so what is the address for correspondence? Who the inventor or inventors are? You can have one inventor, you can have multiple inventors, you can have an inventor and a company or an organization or an institute. It could be a shared invention, or it could be a proprietary invention itself. Um, Next, this is the continued application form. You have the particulars for filing. If you have an international application number, Sakshi, to your point, if you want to file this globally, if you want to make it country specific, you know, I came across this US patenting application where you have, multiple sliders. If you want to cover the Asian region and the European region, if you want to just cover the American region, um, how broad or how specific you want to make this application or grant of the patent. You have different sliders in there, or different options. Then those are just declarations. Below there you just have signatories, sign at the end, and you just submit this online. Now, along with the application, here comes the very critical and main portion of it. Just trying to see how much time we have covered. We still have half an hour. All right. So continue to the steps for obtaining and maintaining a patent. Here is how you would write down a patent. And just so you know, everybody, I'm going to give you a fun activity in the end for you guys to complete. Obviously, we're not going to have time to discuss that activity back, just like we did in the earlier session. You won't be able to have an interactive session, but just so you guys get used to how to file a patent on a very, fundamental level. What are the things? What are the main constructive points while filing a patent? This is just for your reference so that it helps you understand what are the things that come into question, what are the things that an officer is looking for when he or she goes through your patent, etc., etc. So let's start with the very basic, the title of the invention. um, so this title has to be very specific, very on point, as I would say, to what you're asking for in the application. If it is a product, it should be, detailed product title of the invention, or a detailed title of, not a detailed, but a very brief title of the process for which you're claiming invention of. Um, so that is the title of the invention. The next thing you have is cross-referencing to related applications. So remember on the previous steps where you did the research or the background study on previous art. So this is where you would refer all your previous background research work in your application. So talking about number point two here, you would say patent number XYZ by so and so company or inventor states this. So this is just your, I would say, literature, just kind of literature and thesis. So this is your cross-referencing of previous artwork. This is something which relates to your patent or to your application or to your product or to your process. This this is not your product or process. This is something that relates, or this has some similarities or some, um, you know, inspiration maybe from earlier filed patents. So that's number step two. Now, in step two, what a patent officer does is strongly proofreads I would say, or strongly determine if you have something unique or different than all the related applications you have cross-reference to. So this would be a very critical point. And even if you miss um, um, some previous artwork or something, this gets notified. They know about all the previous artworks. They do their own cross-referencing of your patent, but this is just so that it makes it easier for them to understand what was your inspiration, what was your background on getting to this stage. So this is number two, is just short list, or one paragraph of what the cross references are. It's basically what we have references at the end of the thesis or end of the article. So you're just cross-referencing your work. The third thing you have is statement regarding federally sponsored R&D. It could be some grant that you have received from government. It could be some, all the support, all the help you have received from different laboratories, different accredited institutions, different ministries, different sections under different industries, and so forth. So this is where you would entail everything that you have received as far as grants are concerned. The fourth thing you have is detailed description of background of the invention. So this goes back to number two, but here is where you would get your floor. This is your floor in explaining what your product is all about. So how you would do basically is number two, state this is where my inspiration is from, or this is where my background of the patent is from. But in number four, you would describe all the distinguishes, all the similarities, all the differences, etc., etc. So talking about number four, you can say in claim number or in patent number XYZ, the product has this information, but in my claim, I'm focusing, or I am, my product covers this thing and not the other thing. So this basically is just an open floor for you to say, how is your patent or how is your product useful, novel, non-obvious, different from the earlier work, etc., etc. So this portion number four covers majority of the paperwork. This is where an officer decides more or less if your patent claim should be granted or not. There are so many objections raised in this particular point. Obviously, there are objections raised on other points as well, but you can fight back on those points. But number four is where most of the red flags are raised, and you would have to be very specific. Now, one thing I would like to mention here is patenting is all about, not all about, but it is very, very, very vocab focused or vocab oriented. Each and every word you mention in your patent has its own stand, has its own worth. Um, you know, every word you mention has its own meaning. And similarly, you have to paraphrase each and every segment, each and every point where you try to distinguish your product, your work different from the others. Um, the next thing, so number four, companies, big MNCs, when I said earlier, they try to find their own ways around. This is where they find their own ways around. They don't do major changes. You have iPhone 10, 11, 12, 13, 14, 15. There are not major changes, except for instead of two cameras there are three cameras. Instead of um, squared edges you have round edges, etc., etc. There are no major changes from previous work to the new work, but all those minor details that you find, the curvature, etc., etc., all of this has to be very, very, very explained in detail in number 4. The next thing you have, number 5, is brief description of the drawings or the drawings itself. um, so this is mainly for products, wherein if you have, let's talk about textile here for a while. You have a textile material like a woven material. um, you would explain what the woven structure is, what does each structure represent, what is a warp, what is weft, what does it consist of, how would it look like in a microscopic view, how would it look like when I'm just seeing it with my naked eye, um, and etc., etc. And just in a while, I'll show you some of the existing patents. Um, the next thing you have is you describe in detail about the drawing, um, wherein you say you have call outs in the drawings where you have, this is number 1, this is number 2, this is number 3, and sorry guys. So in the detailed description you have, you explain each and every call out. So you refer back to the drawing, you say number 1 is made up of this, it's made up of polyester, this is the count, this is how it is made, referring to the diagram. The number 7 you have is actual statements of the claims that you're asking the patent office for. You have, so whatever distinguishes your product, in short, from the others is whatever you're claiming to file for a patent. So all those claims have to be explained here in number 7. Just remember, number 7 is the point where you would, or where the officer looks at the claims and you get your patents for, or you get the grant for patents. All the previous points is just you trying to explain your product or your um, application. Number 7 is the point where what you're trying to claim um, with your product. And number 8 you have is summary of the invention, where you summarize the entire paperwork just to make it easier for future researchers, scholars, industries to, if they're going through hundreds and hundreds of patents in a day, they can just look at the summary of the invention and the claims and, do their own study. It is also for um, beneficial for a company where they just summarize the whole invention in a short paragraph. So summary is also something which is short, sweet, simple, which explains your entire claim, which explains your entire patent, which explains your entire product in short. So this is what you would submit with your application here. Now, just to make it easy, you can apply for this patent and you would get close to 18 months. I guess Professor Katkar said 12 months. Around 12 to 18 months, you get to work on this and submit your what I call is paperwork, or submit your application or claim to the office. Now, all of this is done, online these days. You can prepare a draft of everything. You can submit this online in the portal. In those 18 months, you can also go back and modify some things. Obviously, you have to highlight the things you're changing, so it makes it easier for the officer to understand what the differences are or what the revisions are. Um, but basically this would entail or encompass your whole patent as a whole. All right, I'm expecting a few questions here, guys. I need to know if it was, if I made any sense.
No questions, sir.
Well, that's good. I'm expecting some patents to be filed after this lecture then.
Yes, yes. That will be
Sure.
outcome of today's session.
Professor Katka, your office will be, everybody will be rushing to your office after this lecture.
Hope so.
All right, before we go to
Many
this,
actually, Pranil, many students they work on different projects which could be easily patentable, but
right,
because of just awareness, they couldn't. So that's why
that's
I had suggested you even in last lecture, like we should give some activity wherein they can learn how
right.
to file the patent, and then after they can take the follow of the same.
So actually what I wanted to do right now in this time frame was actually work with them, show them um, how do you go online, what is the website, how do you look for a patent, what is that you would study, what an actual patent looks like, so that they have something to refer to.
Right, right.
So I just see this work more effective than me just showing you slides. Um, so in the US, let me minimize this so I can see my screen. In the US, what we do is there's a very strong website that has most of the patents readily available. Um, so lens.org is the website we or most of the researchers in the US use for their background study, for research work, etc. So let's say I want to search for. I'm not going to search something textile specific just because I have a fun activity at the end. But I'm going to search for something non-textile. Um, say and just so you know, this is a very strong patent search engine. Just like Google, this website is a search engine for patents. You can search using company names, you can search using inventor names, you can search using different keywords. You can say smartphone case, metal, and you will get all the patents that relate to those keywords. So you have a smartphone case for electromagnetic wave shield, you have handheld mobile device with hidden antenna, you have smartphone cover case equipped with thermo element, etc., etc. So the really interesting thing I like about this website, it gives you um, infographics or multiple informations in different pictures, graphs, charts, etc. So on my screen, the middle section you see um, are the patents. Now, these patents, if you look, some have been filed in, this is a Korean patent, this is a US patent, so this also has patents from all around the world. This website is considered to be one of the strongest patent search engines um, used in the current world, in the current time. All right. So just as a highlight, over here at the top, you have 142,963 patents just related to these three keywords. If I remove any of the keywords, this number would spike up significantly. You have families where you have chains or branches. I don't want to go to detail, just trying to focus on more basics here. And we also want to study a patent as well. Um, on the right hand side, you see the applicants. You have all the major applicant companies, who own these patents. You have Samsung, Intel, Sony, Apple, um, AT&T, Qualcomm, etc. This shows you how many patents were filed over a period of time. So majority of the patents you have were filed from somewhere in between 2012 to 2022 up to date. Um, then you have the legal status. So this file over here shows you everything, the patents that are active, that are pending, that are discontinued. Discontinued means they have already been in action for, or they have already been active for more than 20 years. So after 20 years, remember when it becomes public. So these are the discontinued ones. Um, you have jurisdictions where, where was this filed, or what does it cover? What is the demographic location it covers for that patent? You have the inventors, where you can see this guy, Henry Paul Shala. He has over more than 100 and around 100 and 1200 patents, 1184 patents from just one inventor. So you can see the major inventors in this. Then you have document type, not necessary right now. And on the left hand side, you can apply different filters where you can say, I just want to know, um, let's go for China, just one from China. Let's go for, so I want to see all the um, patents from Apple. I want to know only those that are active. And once I define, it'll show me all the patents filed by Apple over a period of year by so and so inventors. Um, and here are all the details of those patents. Now quickly, we will do a quick search on a textile related patent. I'll go to new patent search here. I'll say 95 face mask. Just use these three terms. All right, the first company you see is 3M here. They have 83 patents just in this N95 face mask keywords. So let's go for 3M. All right, I'm going for something basic. Let's go for the newest patent that was filed by 3M. You can also see the pending applications here that have not been granted as a patent. So let's go for this, a respirator having optically active exhalation valve. I go to this, and here you can see download PDF. So this is how a patent looks like. Now, if you just want to quickly review what the patent is, you can look at the abstract, you can look at the claims that this patent is about. You can look at the inventors here, but if you want to study in detail, you can download the PDF, and it's completely free. It's used for everybody. You don't have to create an account. But let's look at the patent here quickly. Have a glance at the patent. So this is the patent number that you see here. At the top, you can also see the patent number over here. This is the date when the patent was filed. You have the basic application information on this page, where you have a small abstract, um, you know, close to summary of this patent. And then you have a small diagram of how this looks like. Now, this is not a very detailed diagram. We'll see a detailed diagram below. So these are the references or the previous artwork. You have other publications. If you have some background research from a book or an article, all of these are just previous patents filed. Now, this is a diagram. You have different callouts of different pieces of that particular product. And you have another diagram over here that shows you what the different parts are. In detail, they are trying to explain each and every part. So you have an overview diagram, wherein this particular part is explained separately. You have this particular strap, this particular piece explained separately here. So here are the results of the tests that they have conducted. So this is where the real, the floor that I was talking about for patent applicators or patentees, where they can explain everything they want to regarding their product or the claims they are trying to make. So here is the background of this claim that the company is trying to make or the inventor is trying to make. Um, right. So I was looking for this. The brief description of the drawings tell you what each and every part in the drawing means. So down below there, you're trying to explain what number 10 is, what number 12 is, what number 14 is, um, in different figures. Then you have a summary over here, which explains your entire claim or entire patent as a whole. And these are just glossary terms or the tests you have done. This portion over here looks more similar to a thesis where you say these are the claims you're trying to make, these are the tests you have conducted, these are the results from the tests you have conducted. If your material has a, a certain process or a certain process flow, this is where you would detail everything um, in here. If there are different design of experiments you have tried, if there are different hypotheses you have considered while testing this, different conditions, um, all of this would be detailed in here. And so the long list, what we are trying to see here is detailed description of the preferred, callouts from the diagrams. So here you would say figure 1 illustrates an example of a filtering face mask. that may be used in conjunction with the present disclosure, what each and everything in the diagram represents. So this is the packet that you will turn in with your actual application, and once it has been granted, you'll get a US patent number or an Indian patent number. But if it is still as an application, you will still have an application number for your reference. So if you look at number 21 over here, you have an application number which turned out to be a patent number at the end. So you have all the inventors here. The assignee is the company, meaning the company is paying for all the maintenance charges, but the inventors originally were these mentioned in number 72. And again, you would just go to that particular patent and go to download PDF. All right, any questions so far? Now I'm going to help you. Go ahead. I guess someone was trying to speak. Anyway, so at the end of this, yeah, go ahead.
Okay.
Yeah, Kiran. Yes, Kiran.
So it was Kedar, not Kiran, sir.
Kedar,
He
sorry,
tried to
Kedar.
spoke.
Can't hear you, Kedar. I guess you're on mute.
Hello.
Hello, Kedar. Kedar, you are not audible. Hello, Kedar.
Kedar, let's take it.
Kedar, you can drop your question in chat box.
Yep. All right, so I'm going to make it super simple and super easy for you guys. So at the end of this session, I'm going to give you this slide for reference, but I'm also going to give you some websites that you can use. There are patent building websites where you just have to, just like a form, you fill in everything that they ask. There will be a question where, there'll be a box where they're asking you for diagrams. You can upload your diagrams. There is a box where they'll ask you for the description. You just have to write a description. These are just tools that you can use, especially especially to make sure you're not missing something, especially to make sure the content you're providing matches to what the requirements are. And these are just free to use tools where you can just go in, create an account, fill out that form, and it'll give you it'll turn or it'll convert it into an application for you automatically. So that'll be really helpful just in the starting stages um, when you're trying to build this. So the bottom line for patenting is, and these are the questions you need to ask right before you try to file for a patent. Obviously, everything comes at a cost. So can patent expenses be recovered? For example, if you have invested, let's say four to $5,000 or 2 to 3 lakhs in a patent, I'm just throwing out a number. I'm just ballparking. But if you're throwing around a few lakhs, few thousands in a patent, can that be easily recovered? Does that patent have a value? Um, could it be commercialized? Can you sell it to somebody and just get some royalty? Can you, um, earn some money from that patent? Can you monopolize the market using the patent you have? Um, so these are the questions you need to ask before actually filing for a patent. Would it be easier for you to, include somebody, not at this stage, or maybe at a later stage once you have a patent, or maybe at an early stage, so that they can help you commercialize this product in the market? Can the corporation or the firm or the organization or an institute you're working for or whoever is the assignee afford not to patent the technology or afford to patent a technology? Meaning, if you have an idea, you're working for a company, and the company does not want to patent it and just want to sell it in the market, and if somebody else files for an application first, um, you can no longer have rights to that product, even if you were the first one to introduce it to the market. So remember the law of or the rule of patents: first come, first serve. If you file it, or if you claim to be the first owner of that particular patent or an application, or if you are the first one to claim, you are the owner of it. If you are the founder of something but you don't claim it, and if somebody else claims it, you no longer have the rights for that particular product in the market. And the third question, which I have not included here, is can you actually maintain the cost of a patent? So let's say the patent filing cost is a few $1,000. You file for a patent, you get a patent, it is approved, and then every year, every 3 years, there is a cost related to it. Are you um, able, or I would say, are you willing to pay for that cost? Is it really worth to pay that cost? Um, all those questions are the ones that you would have to answer. All right, so with this, we come to an end with this session. But before we sign off, real quick, to me, especially to me, and this is just subjective again, but I've heard from a lot of people, filing a patent is not a fun activity. It is not fun at all. You have a lot of back and forth with the officer. It's basically you trying to convince somebody that what you thought of is, really patentable, which is not fun at all. There are costs associated with it. You put in a lot of efforts. It is time consuming. You have to wait. Sometimes you also have to wait for months and months just to get a response back. I guess Professor Katkar has long experience with this, or in-depth experience with it. So, but anyway, from what I have heard from different inventors or different patentees, is it sometimes it could take years and years, to get it approved. But yeah, for today, we are going to do some not so fun activity. um, I would ask you to write a 2 to 3 pager patent on any textile related product. And that is why I was just trying to stay away from textile products in this session, so that, whatever you can think of, whatever you can come up with, which is textile related, um, you can write down a 2 to 3 pager patent on that. This could be something which is already existing in the market. You can also go to a patent website. You can read the patent and summarize it in your own words. Don't try to directly copy and paste everything from the patent. It won't be really helpful to you. just think of some textile product, or it could be something which is your unique idea. I would prefer not to do so because you don't want to leak the idea to everybody, right? But just something which is already existing in the market is fine. This is just so that you can get used to filing a patent. Include some drawings of the product. It could be rough sketches. It could be something, from the internet. But what I want you to do is explain the drawing in your own words and how that is different from the other products. You can submit this to Professor Katkar as you did previously. And what I'll do to help you with this is I'll provide you the resources, some references, some websites you can refer. These are very, very, very easy to use websites. You just go in, it's just like Facebook or Instagram. You go in, you make your account. Some of the cases you have to make your account. You just answer to the questions they're asking you, and at the end, they'll give you, a patent application of your own, like a proper file that you can use for your reference or for future reference. So I'm going to provide you with those resources, or I'll just email it to Professor Katkar, and she can forward it to you all. All right. So with this, we come to an end to this session and overall Unit 6. And with this, we also come to an end to, I don't have any further sessions with you guys. So if you have any other questions, any feedback, any comments, feel free to reach out to me. Professor Katkar, in the email that I'm going to share with you today, I'm going to provide the resources and the contact information. So if you can just forward it to everybody on this call,
Yes,
I'd
yes.
appreciate it.
Yes, Kid. Yes, Pranil. Pranil, there is a question by Kedar in chat box. Like, what are the claims in patenting, and how can I know originality of my idea or product before filing for patenting?
Okay.
Kedar, are you there?
Hello, yes.
Yeah.
I don't know why I'm not able to see the chat box here. But from what he said,
Shall I repeat the question, Pranil, again?
please, from what I understand, he's just asking for
Like he is asking about the claims. What should be the claims we have to write during filing the patent? And second thing, how I could know the originality of the idea or product before filing the patent. So
okay.
it's about searching and writing the claims.
Okay. I'm gonna share my screen for a moment here. That's a good question. So the originality of the claims, Kedar, you would have to do an in-depth study and research on the previous work that has been done. These tools here are of great help. What you can do is, let's say you come up with a new fiber. Uh, you know, I'm just making it up. You come up with a peach fiber. Okay. What you can do is use this tool, use different websites that I'm going to refer to you. You can type in the keywords. You can go to the internet. Um, you can search for those keywords. You can search for peach fibers, peach related fibers, fruit fibers. If you come across something, uh, try to look more towards in that direction, and you'll find if there is already something that exists in the market. The next thing you would do is go to the patent websites or patent um, offices. website and try to search for the same. One thing which you would find is there could be already patents existing, but no research work on the internet, which is highly possible. But in most of the cases, you would find some background work, some literature related, if there is something already in the market or already existing or already claimed before. But in the other cases, you would go to this website or similar websites. You can search for keywords. So just to make it interesting, let me search for a peach fiber. Okay, there you go. There are already 7,655 related patents. Now, this could be something that is related to what you are thinking. This could be something which is totally unrelated. But for this, you would have to go to, similar uh, claims or similar patents, study those patents in detail, read the abstract. There are no claims in information available in this, but looking at the abstract, it's like 100% terylene filler composed of 40% peach palm fiber, blah, blah, blah. Most of this you would understand from this itself. If you find something which relates to, what you're thinking of, it is something already in the market or it is something patented. But what you can also do, there could be even 10 to 20% dissimilarity or uniqueness in your idea, which could be patentable. And this is completely subjective. You can go ahead and file for a patent. So let's talk about claims, the second part of your question. Okay, this is out of my expertise. Let's go to some other um, um, let's go to the previous one.
Pranil, I guess the claims are related to the things which are specifically related to the product or idea which you are going
Right,
to file, right? And
right,
then you should not, like, this is the heart of your patent. We are not supposed to miss out anything
right,
so that others can go for the claim.
right. So companies will really try to find loopholes in this. If you forget to mention a single word or something very critical to your um, claim, they can file the same claim but using a different product. So let's say
Right,
you come
right,
with a fiber uh, which is a totally different fiber, a new fiber basically. You can claim for that fiber or a product related to that fiber, but make sure you also include a certain range. If you're claiming for, you know, um, let's say a peach fiber, which is 30 to 60s count, there could be companies filing for claims outside that count because your claim is just restricted to that count, to that size, to that condition, or to that orientation of fibers, or whatever it could be. But claims are very specific, and you have most of the details in the claims. This is something you're um, basically fighting for. This is your patent. So make sure you have most of the things in the claim itself. All right. Any other questions?
There is one question from my side. Pranil, have you came across any sort of like template thing through which students can learn the points? Like if they just go on putting the write-up there in that template, they
Yeah.
can learn very easily how to go for patenting.
Yeah.
So
So I'm going to share that resource with you. I have a few websites that can do that easily. Um, it's basically just like I should say making a Facebook account. They ask you for a name, you type your name. They ask you for your date of birth, you type your date of birth. They ask you for patents, they ask you for claims, you list down your claims. For claims, they also have a reference on, what you should include, what are the main points you should not miss. Um, for previous research, they have the patent number, they have the date of the patent number, they have the claims of the previous work, etc., etc., which makes it very easy for them. So I'll be sharing the template with you.
but then are they trustworthy, these sites?
Um, they they are trustworthy to some extent, I would say, but if you just um get the gist of that particular template, you can make your own template in Word format. Just just as a reference, that would
Yeah,
act
yeah,
as a
yeah. That
reference.
that that can be the solution.
But most of them are end-to-end encrypted. I don't think so. They make use of data, but those are trustworthy websites that I'll be sharing.
Okay, okay. Thank you, Pranil.
Yep, no
Any other
problem.
question from student side? Any questions?
No, ma'am.
No, ma'am.
Any
All right.
feedback? Feedback from student about all the three sessions by Pranil sir. Yes, Harsh.
Just so you know, Professor Katkar is just asking for good feedback, not bad feedback. I'm
Actually, the
just there.
sessions are really good, Pranil. Those are informative. Students can learn a lot through all the three sessions.
Yes, sir. So it was really great, like learning from you. Like you are so young
Harsh, you
and
are not audible.
We
Please
can
speak
hear you,
loudly.
Yash, but we can hear you, Harsh, but it's just too much disturbance.
Yeah, yeah.
yeah.
Harsh, please continue. Any other student?
Hello, sir. It's
Ma'am.
Vaibhav here.
Yes, Vaibhav, you
Hello.
can continue.
Yes, sir. Sir, you thought stage gate theory from first lecture, so that means I think that is a difficult concept, but you thought as a easily way. We can understand easily about the stage gate theory, and now IPR is also you thought easily, sir. So thank you, sir.
Thank you, Vaibhav. I'm
So
glad you could.
actually, this is a really good feedback, Pranil, because the complicated things, it's a teacher's role to make the things easy,
Right.
complicated things rather. So it's really good, Pranil.
Yes,
Thank
sir.
you.
There is Akash is there, sir. The way you are teaching or give the live example about all related fields like textile is very good, sir. And the way you teach is very interactive, and it's knowledgeful, sir. Thank you, sir.
Akash, the sessions were interactive, but you didn't speak up a lot.
Sir, I
That-
speak, sir.
Just so you know, Akash, I'm making a list of everybody who's talking. So
Yes, yes, sir.
I don't have your
Pranil,
name on the list.
yeah, Pranil, there is a
Sir,
feedback from Harsh in chat box.
Okay.
It is great learning from you. You are so young and knowledgeable. Lectures were fun and interactive.
So Harsh, next lecture is going to be from you once you graduate from DKT. Thank you, Harsh.
So this is Sakshi here.
Hi, Sakshi.
Yeah, sir. So year back there was a session of yours under Taimu. That time I saw your bio. Like I was the vice president of Taimu Association, and I was not knowing that I'll get a chance to learn from you, and it was really great learning. From the stage gate theory till today, everything like you sorted it so simply, and we are ready to answer any question related to it. And even I'm doing a project for my final year, and it's related to product development. And even my plan is to get a patent on it, so it will quite useful for me even there. So it was really good.
I'm glad I could be of some help.
Thank you, sir.
Hello, sir.
Hi, Shreya.
Hello. Hello, sir. It was nice session. I didn't know any basic concept about IPR, but right now all concept. Thank you, sir.
Thank you, Shreya. All right. I wish everyone all the best for a great future. I'm glad I could be, a small little bit tiny part of building your future career. I'm glad I could be of some help. You could get some information from me. Everything we shared, obviously, or everything we discussed is, you know, theoretical, I would say. The real world is completely different. I'm not just trying to scare you, um, but it is the reality. You will come across different things. Do not stick to only what we have learned in the sessions. um, Whatever we are discussing or whatever we have discussed, it is not the end of the world. You can find some better tools, you can find some better approach, you can find some better answers to the questions. So just don't make these sessions as the end of the world. So feel free, keep your mind open, keep your eyes open, look out for new tools in the market, new approaches, learn from different people. I could have my opinion, somebody else has their own opinion. Be open to all the opinions, hear everything, do what you want to do. Um, and I wish you all the best.
Thank you, Pranil.
Thank you,
Thank you,
sir.
sir.
Thank you, sir.
Thank you,
Thank you,
Thank you,
sir.
everyone.
sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
All right. So I'll wish you all good night, and I'm going to bed now.
Yeah, good night, Pranil.
Yep. Good night.
Okay,
Bye.
Good
bye.
night, sir.
Have a nice day, everybody.
Good night,
Bye.
sir.
Good night, sir.